Good morning, everybody. Good afternoon, rather. Happy Christmas, too. This is CASCAIDr's last podcast on public law principles, and we have saved one of the most important, undecided moot points of the whole public law framework to the very end of the series. And that's not just because it's taken an effort to write the lecture from scratch, because it's not something I've ever prepared before, but because the law itself is moot. You may quite like that word there on the title screen, unconscionable delay. It kind of rolls off the tongue. And what this refers to is the interesting conundrum that in welfare law, so I mean continuing healthcare, education law, housing law, benefits law, and Care Act law, and Mental Health Act aftercare law, those are my sort of favorite 5 or 6 topics. I think that we have this very interesting conundrum that there is a public law principle that a duty is a duty, but on the other hand, nobody's doing their duty and nobody is litigating about it. You would have thought, wouldn't you, if a duty was a duty, then maybe in the instance of COVID, there was a bit of an excuse, but in terms of everyday, ongoing Care Act discharge of functions, you would think that a duty meant that something had to be done. But we know from the referrals that we get that life is a constant stream of being ignored by local authorities at the moment. We get ignored too, lawyers get ignored, but no cases are actually coming to court about the duty to meet needs in the Care Act. And that is a puzzle, because if a duty is a duty, then surely there'd be some legal aid lawyer who'd want to make their name. So this is a lecture, unlike the other lectures, which are about decided case law, this is a lecture about where the law might go to. I would say many councils are not just doing their Section 114 notices at the moment saying that they're about to be bankrupt, but they're blatantly ignoring the Care Act and public law principles because they have no staff and no money. But as I said, there's no case about it yet. So how can this be? Now, in public law, some duties where the statute says shall or must are what is known as strong duties, though they are clear and they are enforceable by individuals who are bothered to use judicial review. Whereas other kinds of duty are called target duties or general duties, where there is a shall or a must in the statute, but the wording conveys that the duty is owed to the general population or to a group, for instance, children in need. So a strong duty would be one that would be crystal clear and tends to generate a right of real substance for an individual, not merely a procedural right, for instance, by way of a duty to give advance notice or a duty to give reasons. That stuff is important, but it's about due process. The stuff we're talking about is the duty to actually do something, and that duty is owed to an individual. And the great thing about the Care Act is that it contains just such a type of duty. The duty to meet needs is a strong duty, which 25 years of judicial review has underlined is a duty that is enforceable by individuals through judicial review. There's also the duty to assess, or a duty to get someone's consent to do something. They are sometimes called mandatory duties by the courts. And whenever a judge says that, focusing on the shall or the must, and the clarity of the duty, and the fact that it's owed to an individual, the judge will often say this: these duties are not able to be downgraded into a mere option or a discretion at the choice of the body owing the decision or owing the duty. There are some duties in welfare law that have been interpreted as less extreme. For instance, a duty not necessarily to bring something about no matter what, but a duty to use best endeavours. And that tends to be in the face of the likelihood of difficulty regarding the delivery of the duty, or where there is an interface with some other agency that may well be in the frame if somebody else doesn't do it. And in particular, that's Section 117 of the Mental Health Act. It's never been the case of the Care Act duty or its predecessor that it's been merely a duty to use best endeavours. It's always been, the duty to meet need has always been a mandatory, enforceable duty, and there are no two ways about it. The duty to meet needs must be discharged regardless of available resources. The best endeavours duty, as I said, is the interpretation of Section 117. And for those of you whose loved ones may be owed CHC, continuing healthcare, the nature of that duty is a bit of a fudge. It's somewhere in between. There are no individually enforceable duties in the whole of the NHS legal framework. But a bit like with what's happened for Section 17 of the Children Act, which looks like a duty, but it's a duty owed to children and children in need. The courts have not just looked at the bald wording, and the courts would be expected, if anybody took a CHC case to court, to say that at the very least, a strong duty to assess and to assess subject to public law principles arises in CHC cases from the very context of the duty to provide for a comprehensive health service, that's the duty under the NHS Act, and in the case of people who've got a primary health need, since it means they can't get the service from the council, who else is going to provide for them? Once an assessment has been done, it's impossible to envisage a court saying that it's only a duty of best endeavours to provide the healthcare, we think. And that's why we think that there's a political framework for CHC duties being enforceable, even if there is no case on the actual subject matter. Some duties are so strong that they're even to be discharged without regard to available resources. And before you choke, I'm going to say, honest gov, it's actually true. The assessment duty is one of those. Another example is the provision of statutory advocacy. It isn't an excuse to say we haven't got enough money or we haven't got enough advocates. The same with mental health review tribunal scheduling. There's a famous case back in the early 2000s in this PowerPoint where a great judge says to the government, it's too long to leave people for 4 or 5 months because of waiting lists for a tribunal. I don't care that you haven't got enough trained tribunal chairs. You've actually got to train more. You've just got to throw money at it because otherwise it's a breach of human rights. And it is, or has always been thought to be the case with the duty to meet Care Act needs. Resources are not relevant to whether a duty is to be met, but only relevant to how the need is to be met. If you've done my courses, you would understand that it says that in paragraph 1027 of the guidance. The trouble is, though, and I have to be the first to admit this, some of these strong duties have got no set time limit. And so their discharge is a duty, but it must simply be completed within a reasonable time. And that will always depend on the individual circumstances. So there's no time limit for how soon should an assessment start or be finished. There's no time limit for how soon should a care plan be completed and signed off. Some of these areas of law allow public bodies a very long time indeed, and the most obvious one is the duty owed under the Housing Act to provide long-term accommodation for people. It can take years, in effect, to get to the top of the housing list. Sometimes where the real problem is central government funding not being enough to the body that owes the duty, here local authorities, the legal argument would be anticipated from the council that it's not even appropriate for the courts to get involved. because these are matters of extreme strategic sophistication and nuance, the management of scarce resources. And that's called contending that the matter is non-justiciable. I can just see I've spelt that wrong. So in terms of adult social care, what is clear? Well, the duty to meet need on a finding of eligibility is strong, clear, enforceable, and mandatory. Local authorities don't have a duty to meet all needs, but eligible unmet needs. And Section 18 makes that clear. A local authority having made a determination under Section 13(1) must meet the adult's needs for care and support which meet the eligibility criteria. The duty cannot be excused for want of financial resources. The courts have been saying clearly since 1997 that the budget of the local authority is only relevant to how the need will be met. And there's a line of inappropriateness and meanness below which a local authority cannot go. The state of the budget on any given day is not a legally relevant consideration in terms of whether a person is owed a duty, i.e. whether they're eligible, or and it's not an excuse for not meeting the need at all. As I said, there's no time limit. The duty to meet the needs, though, does date back to the eligibility decision. And once you know that, you can perhaps understand why local authorities have bought into streamlined systems for assessment that never really seem to trigger an eligibility decision. That's just hopped over, and that makes it much easier for local authorities to avoid liability. Now, let's think back to COVID. During COVID, all bets were off. And there was not just a lack of money, which was systemic, but there was an unexpected problem. There wasn't so much a policy of rationing the funding, but there was an unexpected difficulty and set of problems. And I think any English person who was brought up to be rational would have expected the courts to be generous about delay during COVID. But we haven't got COVID any longer, and yet we have got a disregard for the rule of law because the CARE Act contains such a strong duty that it was suspended 10 days into lockdown. The NHS duty wasn't suspended because it doesn't give rise to an individual duty, but the CARE Act one was, and local authorities then had to consider whether they needed easements. The only reason for that suspension of the CARE Act must have been that the courts were afeared, that government was afeared that the courts would make findings of breach of statutory duty. To my mind, the general context of the CARE Act, that it is a safety net, that it is a residuary set of duties owed to people who can't otherwise cope in terms of money or mental capacity. And bearing in mind the consequences of not meeting the needs, as the person's plight gets more and more urgent, it begins to spill over for the rest of us because we can't just lock people up. Well, in that situation, I can't imagine a stronger duty than the duty to meet needs under the CARE Act. So I am not surprised that the CARE Act was suspended. And I happen to have a very good reason for knowing that the government would have been peculiarly aware of the duty being a strong one. It so happens that in February of 2020, before the pandemic was announced as being here, I had occasion to write to Dominic Cummings about the problem in restitution. In other words, the Court of Appeal decision from 2019 that says in terms that if the CARE Act is breached, a local authority can be made to pay back money to people who have stepped up and done the work themselves or spent money on getting other people to do it because they've saved the local authority money. And of course, I never got a reply from Dominic Cummings, and his desk became somewhat full as he was running the country at that time, so it is said. But I think that that had something to do with the Care Act being suspended. By the time the Care Act was no longer an issue and easements had been taken off the table, of course, the rule of law had already been fatally holed, diluted by the fact that nobody expected anybody to do anything normally during COVID. It so happens that you don't have to go to court about delay. You can go, if you don't want much money back, you can go to the local government ombudsman. And to just give you an example, on our website, we've got complaints analysed about delays in assessments, delays in implementing care packages, delays in moving people to a halfway decent setting, delays in financial assessment and delays in invoicing and delays in backdating repayments, delays in reviews, classically, delays in replying to complaints, and of course, delays in disabled facilities grants, occupational therapy assessments. Constant delay in carers assessments and delay in DOLS assessments. And there just happens to be on this slide an example from Medway, where there was a delay in completing an assessment of over 5 months, much longer, the Ombudsman said, than the expected 4 weeks. The Ombudsman has a gut feeling that 4 weeks is long enough for most standard assessments. It might be 2 months or 3 months for a complex assessment. The Ombudsman doesn't have a case to go on, but thinks that that's good practice, and it makes sense given that local authorities are supposed to have competent, trained staff. In this Medway report, the Ombudsman was generous about some problems being beyond the control of the council: COVID-related difficulties, staff vacancies, social worker turnover, the availability of suitable accommodation, and limited medical information about Mr. X. But the council was still found to have been at fault. And the Ombudsman talked about restitution, etc. He said at the end, or the investigator said, as Mr. X was still in his own home and there was no solution to his housing situation at the time, he should have been provided with more care support in the meantime to meet his identified needs. In other words, you can't just have an assessment going on forever without providing interim services. Now, whenever we hear about staff turnover, I find it fascinating that nobody ever mentions this act. This is Section 6 of a 1970 piece of legislation, which provides for the appointment of a head of service called the Director of Adult Social Services. And it goes on to say at subsection 6 that there is a duty on any local authority which has bothered to give somebody this title. A local authority which have appointed or concurred in the appointment of a person under this section, a DAS, in other words, a Director of Adult Social Services, shall secure the provision of adequate staff for assisting him or her in the exercise of those functions. So this is a duty on a local authority with social services obligations to fund sufficient staff so that there is never a social services function delay, to underline and underscore the major importance of adult social services as effectively an arm of the National Health Service, albeit a chargeable one. And this too is a strong duty. I don't think it has ever been used in a judicial review. So how does public law logically deal with the weight in the context of the Care Act in the real world in the meantime? So we're guessing here, but we think that local authorities who are running waiting lists, even though they accept that it's necessary that they meet need, would be needing to show that they were making a rational and evidence-based response about who to meet the needs of first. In other words, they'd need to take account of what is known about the urgency of the situation and ask about it, making it clear that that's what matters, and whether any informal carer who is on the job is able and willing to go on for a bit longer. Not pushing them beyond being willing and objectively able, that is, because otherwise that's unlawful. There would need to be rational prioritization systems in terms of impact, putting out of account any irrelevant considerations. In particular, the person is already tucked up safe in a care home and paying the private fees with their own money. If they're below the threshold, it has been the law since 1996 or 7 that they are owed a duty, and they cannot just be slipped to the bottom of a waiting list on the footing that they're already tucked up safe. We also think that there would have to be a duty to do something like meeting needs on an interim basis. In other words, doing the next best thing than the thing that there isn't enough of. And of course, monitoring and review and constant thinking about who needs to come next. And at the very end of these slides, there is a case called the DMA case, which sets out in a different context, but one that is hugely tempting to draw analogies between. There is set out a list of very similar things, and that this is my rationale for thinking that this is what the courts would say. Now, in the Rickson case, which is back in 1996, a chap was put on a waiting list for day centre provision. There was none that could actually meet his needs. He had specialist needs. It wasn't a question of money. There was literally none. And many local authorities would often say, well, the person isn't going to move to the other side of the country. Even if we followed them with the money, they're not going to move it when it's day centre care that they need. They've got their life here. Local authorities would also say throwing more money at it isn't going to make this centre stand up. You can't just throw money at something, click your fingers, and expect there to be a service. Effectively, it said that since it was doing its best to secure a suitable centre, it couldn't be in breach of its social care duty to meet needs. And Mr. Rickson won his case. The authority had simply taken the unavailability of further facilities as an insuperable obstacle to any further attempt to make provision. And the judge said the legal duty is needs-led and not resources-led. Now, you may start to wonder why lawyers aren't using this law right now. And you might think it's because we've now got the CARE Act. But the CARE Act was a consolidating piece of legislation and not just a reforming one. So there is no reason why these cases wouldn't still be relevant or cited today. The judge said that the authority had to demonstrate that it was taking urgent steps to address the shortfall in day centre provision, and it had to demonstrate what it was doing in the interim to ensure that his needs were being met in the best way possible. It had to demonstrate that it was being flexible, and it would have to be listening carefully to the relatives who might be saying, for instance, well, why don't you just pay us, even though we're close relatives in the same household? That wasn't an example that the judge was giving in Rickson, because the direct payments legislation had only just come in 1996. But it's an example that could be used today. So ultimately, it seems that Luke Clement's view and mine is that being flexible and loosening up may involve having to increase the hourly rates or allowing family members to be employed so that the needs are met. And that would solve a lot of people's financial problems too. Now, this is an early case too, where the question of delay is how long was it acceptable to take before signing off a care plan? Sorry, no, that's the Tucker case. This case is about providing somebody with an assessment. And the judge in this case listened to argument to the effect that assessment was a really expensive thing to do. It takes about 15 hours of professional time. So the argument went that if you could just look at someone or maybe stick a piece of litmus paper on them, you could tell whether they were even halfway likely to be eligible. This was in the days when local authorities set their own criteria. Even then, the judge said that is legal tosh. And the judge said there is a mandatory duty to carry out an assessment. The judge was referring to the previous legislation. And the judge said the authority has no discretion to decide not to carry out an assessment just because it believes that there's no sensible prospect of the individual getting services. And the judge said this has been the law since the House of Lords in the infamous Gloucestershire case. Resources are an irrelevant consideration in deciding whether to undertake an assessment. The cost of meeting needs is a relevant consideration in deciding what provision should be made to meet needs, but definitely not in terms of the question of the assessment. In italics there, the council's submissions were put out, and the judge disagreed absolutely. Even if there's no hope from the resource point of view of meeting any needs identified in the assessment may serve a useful purpose in identifying for the local authority unmet needs, which will help it plan for the future. And of course, help government make a rational financial settlement for local authorities in the years to come. Resource implications play no part in the decision whether to carry out an assessment. There is nothing in the speeches of the Gloucestershire judges to suggest that resources should be brought into the equation in the first stage of the Section 47 exercise, that is, in the assessment and the eligibility consideration. The next case that came along was one involving a woman who had been stuck in an NHS hospital for over 2 years, whilst the local authority failed to finish a care plan. The duty in that case was under Section 2 of the Chronically Sick and Disabled Persons Act. And Richard Gordon, who was the barrister who set this whole community care judicial review wagon going in 1995, he acted for the individual in this case as well, and contended that Sutton had acted unlawfully because there was no time limit for coming off the fence about a care plan, but 2 years, in fact, I think it was 2 years and 3 months of arguing with the mother in this case was unconscionable. And in that situation, the judge agreed with Richard Gordon. The judge said, there is no decision. There are no overall objectives. There's no criteria for the objectives. There is no care plan. There are no costings. There are no long-term options. There's nothing in terms of recorded points of difference. So the judge said to Sutton, what have you been doing? And Sutton said, we've been trying really hard to get the consensus of Mrs. Tucker. Well, the judge said, not to put too fine a point on it, you could have started off with, say, plan number 3 out of the 8 that she doesn't like. She hasn't been unreasonable, but you could have said, we think that we've done our duty. We're not going any further. We need you to judicially review us if you think that it is an unlawful offer. And so the judge found that Sutton had behaved unconscionably badly. Sutton argued that, in fact, Mrs. Tucker should have used the complaints service, and the judge said, I am quite satisfied that judicial review is here the avenue to be preferred. Default powers of the Secretary of State can't be an alternative remedy here, and if the matter were to go by way of the complaints procedure, Mrs. Tucker, as a non-legally aided person, would be forced to argue points of law before a non-qualified body. That could not be convenient, expeditious, or effective. So you can't be fobbed off from judicial review if you've got the guts to do it, just because there is a complaint system. This slide is about the case I mentioned where a judge called Stanley Burnton held the government to account for leaving people to wait for up to 27 weeks for a mental health review tribunal hearing. 8 weeks was considered to be consistent with the legal obligation under the Convention on Human Rights to give people speedy determination of the legality of their detention. 27 weeks was not regarded as conceivably consistent with speedy determination. Now, the judge said in the quote at the bottom, "What is a speedy decision in any given case will depend on a number of factors, but there may be a sudden increase in applications or the intervention of a holiday period, and those just have to be rolled with. That's part of life. But the fact that a patient's case is perceived to be a weak one does not deprive him of his right to a speedy hearing. And if there is unjustified delay before the hearing, the fact that his case is belatedly held to be unmeritorious does not excuse the infringement of his legal rights." Makes you proud to live in a country where human rights are still surviving. So the outcome was, for the government, you've just got to spend the money. The patient's contentions were set out through their barristers, and the judge allowed the appeal. The judge held, as I've said, that the weakness of a case was irrelevant, and also held that although questions of coping with financial funding of obligations was usually for the government, it was different if there were human rights involved. The court would certainly assess the adequacy of resources and the effectiveness of the administration. And therefore, Stanley Burnton studied why there was such chaos in the mental health review tribunal system. There was evidence from people which was found to be very impressive. And the judge said, ultimately, the delays were unsurprising. It had been well understood, and the Secretary of State had no excuse to be surprised. And he said this: "The responsibility for the delays was that of central government. The failure to provide speedy hearings was due to staff shortages or the pressure of work on staff. And it was not good enough, and the judge excused the chairman of the tribunals and said it wasn't down to them, and ordered the court to spend the money." Sorry, ordered the government to spend the money. And I'm wanting you to get excited about this because my view is that if this PowerPoint gets turned into instructions for a barrister for a test case, there's enough material in here for a barrister to be able to write the principles of delay out so that they start to cover the CARE Act as well. The judge scotched the idea that resources decisions are just not justiciable, and explained very carefully that it was to do with the shortage and lack of training of staff. And that meant that the claimant's rights had been infringed. They had not received a speedy hearing. Now, when the CARE Act came in, I'm thinking that some of you are thinking maybe that made all the difference. Maybe the previous legislation said that there was a time limit, and maybe now there is none. Well, I accept, because I am not stupid, that the language of the CARE Act became more flexible than under the previous legislation. But the government and the guidance have never ever said that there was no longer a duty to make arrangements to meet need. Assets and strengths are one thing, informal input from free relatives is another, but for someone who's got none of that available, there is still a duty to make arrangements. The government tried to say that there is a shift in the Act away from providing particular services to the concept of meeting needs in a more flexible way. And that was to allow people more person-centeredness. Section 8, though, of the Act still says how needs may be met, and there are 3 ways. Councils can do it by arranging for a person other than itself to provide a service, or it can itself provide a service, or it can make direct payments. There's nothing significant about the order. I am simply underlining the notion that the duty to meet need does actually mean providing a service or providing the money. In relation to prevention and reduction, the actual statute says the local authority must provide or arrange for services which would reduce people's needs. And in the guidance, there's a chunk on procurement, and it makes it totally clear that local authorities must buy or acquire the services which they have a duty to arrange to meet people's needs. There's no mention there of the problem, what if you can't buy? What if you can't buy? Should you start up providing directly again through local authority staff whose terms and conditions and pension arrangements mean that they are very much more expensive than staff from the private sector? There's no mention of that at all. Surrey County Council is a 2022 case involving services for a 15-year-old girl. And I am moving on from here, from the Care Act to other aspects of welfare law, so that you can see that some judges are prepared to make orders. So if you look at the yellow part, it indicates that the judge agreed with the claimant in all respects that the Surrey County Council was acting unlawfully, made 5 declarations, and ordered the defendant counsel to provide the claimant with the help she needs by making 6 orders, mandatory orders, in relation to her accommodation, care, and education. Now, she is a child. She is not an adult under the Care Act, but it goes to show that judges do make mandatory orders, even if a local authority is wailing, wringing its hands and gnashing its teeth about its lack of money and the impossibility of finding a service. So I don't have time to go into this, but you can see from the emboldening that the judge liked the idea that the council was in the wrong, because there's no defense in the education legislation whereby you can just say, I tried, I've used my best endeavours. And the judge says this: the duty to make arrangements for the provision of suitable education is not a duty to attempt to make arrangements. It's a duty to actually arrange for the provision of suitable education. So it's not good enough just to say we haven't got enough resources or we've done our best. The defendant, interestingly, said that the remedy should be refused, even though they were hanging their heads in shame and agreeing by the end of the case that they'd acted unlawfully. The council tried to say there is no residential accommodation available, no educational setting. The breach of the legislation was a technical breach, because it's impossible for them to comply with all the various duties. The council even dared to say this: it's highly likely that making a court order would make us do anything different, because basically we don't know how to deliver suitable education to this child. And lastly, they threw themselves on the judge's mercy and said, judicial review is a discretionary remedy. Even if we're acting unlawfully, you don't have to make a court order. Anything that you could say to us would really be of no practical effect. That's a brave thing to say to a judge, isn't it? But it didn't go down well. This is not a case, the judge said, where it can be said that it is highly likely that the outcome for the applicant would not have been substantially different if the conduct complained of had not occurred. The question in the Supreme Court Act is not whether any relief any remedy would result in a substantially different outcome, but whether it's highly likely that the outcome for the individual would not have been substantially different if the unlawful conduct of the defendant had not occurred. I do not believe the judge was saying that if I make a court order, you're going to ignore it. Let's just see, shall we? A bit of brinkmanship was going on there. The judge was not impressed. And ultimately, the judge made this long, long list of orders, making it inevitable that Surrey would have to do its job, or its director would be sent to prison for contempt of court. In this case, from many years ago, ordinary housing was provided to somebody under the predecessor to the Care Act, under social care. I don't have time to go into it, but for any of you who are involved with the Rightful Lives campaign to be getting people out of psychiatric facilities into houses, or involved with people who are trying to get people with learning disabilities and autism out of care homes into ordinary housing, then this case and the cases that it mentions are extremely important. It is not okay for a local authority to say, we only ever make care home provision. Now, in this case, if the man had been presented as homeless, he was still going to be about 14 months from the top of the list. And the local authority's social worker assessed the man under the predecessor to the Care Act as needing to be rehoused. And so that was on the care plan. You need to be rehoused. And therefore, the local authority got judicially reviewed in terms of its social services functions, and was told that it needed to go out and buy a 3-bedroomed house for the man and his family in the middle of Islington, probably next door to Tony Blair at the time. Now, I'm not sure that they ever did that, but they were ordered to. Magically, within about 3 weeks of that case being decided, Mr. Batantu suddenly acquired more housing points on the allocation system and was provided with housing through the ordinary channels. But this case is at the fundamental bottom line of the position that people can be provided with ordinary housing. And this brings me to the case where I think the strongest analogy is able to be drawn out. This was a Priti Patel failed case where she was found to have been presiding over unlawful, huge delays in the system for accommodating asylum seekers. The targets for the Home Office were between 2 and 9 days. And in some cases, it was taking like 150 days to find accommodation for people who were already found to be destitute and consequently at imminent risk of their human rights being breached. They were not lawfully detained as such, but they were owed an accommodation function by the Secretary of State. And the provisions of the framework are set out there. Priti Patel was contracting at the price of $4 billion over 10 years with 3 private sector companies at a fixed nightly rate, and leaving the companies to cope with whether they paid that much, less, or more in order to meet these people's needs. So it's not adult social care, but it's very similar to it. The targets for the companies were measured in days, but were taking months. So we've got a target there of between 1 day and up to between 5 and 9. And then in reality, it was taking 45 days up to 151. And in this case, the arguments from Mr. Tam were coherent and honestly and conscientiously put as to why Priti Patel was not guilty of presiding over an unlawful system, but they were not accepted. The judge said, the judge was Mr. Justice Robin Knowles, and he found systemic unreasonable delay, failure to capture data properly, and failure to monitor. So we don't have time to look at the breakdown, and I want to get to the final slide, but he found systemic unlawfulness, breaches of the Equality Act, and important points of practice that were reasons why the judge wouldn't be gainsaid in relation to going ahead and upholding the claimant's case. Ultimately, the barrister said that there was a rule that the accommodation should be provided within a reasonable period, and then set about contending that the period was reasonable in these particular individuals' cases. And the judge disagreed because, as far as the judge was concerned, the context of the scheme was people who would suffer a breach of human rights. They were people who were already vulnerable and had been found to have been owed an accommodation duty. And I'm hoping that you're seeing the analogy there between this area and the Care Act. The judge said a very important thing. He said that for these people, I'm going to be thinking of this situation as being about how to prevent inhuman and degrading treatment, and not just think about the provision of accommodation. This is not an ordinary Housing Act function. And the judge went on to say, if the Secretary of State's position is to be upheld, there would have to have been reasonable diligence, urgency would have had to have been respected, and Article 3 would have had to have been accepted as an absolute human right. And the Secretary of State's argument through this luckless barrister did not achieve the judge's approval. The judge destroyed the argument that the barrister was paid to put forward, and ultimately said this at the end: to decline to improve a system that is failing to meet the requirements of a duty, when that system can be improved, is equivalent to a decision not to perform the duty. It would be an example of a deliberate decision to delay. That's the kind of thing you have to look out for with local authorities. In relation to the barrister's brave arguments that the judge shouldn't even stick a toe in the water of how the Secretary of State was spending this £4 billion over 10 years, because that's for the government and not for the courts, the judge made short shrift of that and talked about the relevance of money, just as, of course, we could say that the problem with social care delay is that local authorities are not paying enough money. The reason they're not paying enough money to providers to come forward is that they're not being given enough money, and that therefore is a central government failing, which has destroyed the rule of law in relation to the Care Act. But the slide I want to finish up with is this one. This is what the judge said about how scarce resources would lawfully have to be managed in a system where there is not enough of something to go around. For it to be lawful, there would have to be these features. There would have to be proper regard to the context for the duty in the first place. These were people who were destitute, who faced an imminent prospect of serious suffering, and who were highly vulnerable. Now, the analogy with the context for meeting adult social care needs is that if people have been found to be in eligible need, their lives are redolent of circumstances that the government has said must not be tolerated by the state, because someone whose situation falls into the eligibility framework is someone who must be lifted out of it, and that's what the duty is for. So an intolerable life, quality of life, through unmet need is a strong context, maybe not as strong as for asylum seekers, but still strong. The feature of any waiting list system would have to identify the characteristics of the individuals involved. It would have to follow the progress of each case. It would have to alert cases that are at risk of exceeding a reasonable time in sufficient time for this to be addressed. It would have to include a regular review of where and why cases were at risk of exceeding a reasonable time and what were the characteristics in that specific situation. It would have to record when a reasonable time has been exceeded, and effectively senior managers would have to take responsibility for that. It would have to identify where and why and with what outcome any individual had applied to the court for an order. In other words, legal risk would have to be acknowledged. And it would have to allow trends to be identified, including by reference to the characteristics of the people who were suffering. And in turquoise on this slide, I have drawn the analogies that need to be drawn, in my view, by lawyers who would hopefully take this field of undecided principle forward. It would, if anybody had said, for instance, if some of the asylum seekers had refused to go to the other side of the country, the judge said reasons for their unwillingness to go would have to be recorded so that the response to the reason and whether the reason was reasonable or not on the part of the person turning down a move, that would be relevant. And that's very reminiscent of adult social care, refusals to try things out. It would have to report on action about any changes made to the system in light of the above features. In other words, there would be accountability. And the judge said this: monitoring is not just about numbers. The monitoring must be accompanied by arrangements to secure action by reference to the information the monitoring provides. The important thing is that the actions will be informed. Now that's the end of the material. And what I wanted to say was, if I unmute people, I'm anxious to grasp from people, if you're still here, whether, in fact, you've understood the significance of what I have tried to set out here. I don't know if I've got any lawyers or any members of Rightful Lives in the room. I don't know whether there's anybody here who is associated with legal aid lawyers who can take these arguments forwards. Because if you've seen our appeal at the moment, CASCAIDr is announcing, and has been for the last 10 days, that it is in real trouble. We are closing today to new referrals. And that is partly because I am stopping being the CEO, but it is partly because it's not so much money. We've still got some money, but we haven't got access to legal expertise. So we can't pretend to be a specialist advice provider if we don't have people at our disposal who are well qualified in this area of law. One of the things we've said we'll do with our money, whilst the senior management team tries for the next 2 months to reconfigure so that we can get connected with people who are good at this area of law, is we've said that we will spend money on barristers' opinions on undecided points of law where local authorities just fob people off, and people can't, in terms of their crisis, plod through enough information on the internet to figure out whether the local authority is telling them the truth or not about the legal framework. And our litigation strategy is part of our appeal. We have a poll out at the moment on our website for what are people's favourite issues. And this is one of them. This is actually one of them. And I believe that although I am no longer the CEO, I will be surprised if this one, the question of unconscionable delay, doesn't make it into the top 4 out of the 8. In which case we have a license to go to any member of the bar. We're not going to bother with solicitors. We're going to find a barrister who wants to make their name writing out their opinion. Hopefully that it will agree with mine, It might not, but we're going to go with it anyway. And then we will air that kind of opinion so that it is easier for the general public to take this matter forward. It doesn't solve the problem that you need to feel safe in bringing judicial review proceedings. If you can't find a legal aid lawyer who is willing to let you over their threshold, then you take on a costs risk. And nobody wants to lose their house because of making legal history. So my point really is that legal aid lawyers ought to be standing in a queue to be involved with barristers who are doing these opinions and finding test cases that will be strong. And this will be CASCAIDr's legacy. Whatever becomes of us, this will be CASCAIDr's legacy, because public law principles should rule, and we should not disregard the rule of law in a civilized country. So that's me about done. I'm interested to know whether anybody would like to speak. You can put up your hand. I've got everybody on the screen at the moment. No need to say anything at all if you don't want to, but you're very welcome to unmute. You've got the right to unmute. Anybody's hand up? I think I have boggled you all. I would just like to say, oh, Mary, okay, go for it.
If you stop taking on cases, so what will happen to people's need?
I don't know, Mary. I do not know. And I can only say that there are some charities that exist. There are some legal advisors who exist. There are some barristers who take direct access. But we may be looking at the end of adult social care law, not because I am leaving CASCAIDr or CASCAIDr is struggling, but the context in which we are struggling is the lack of interest on the part of legal aid lawyers in taking forward those cases, because they cannot make money from them on legal aid rates. Nobody does anything for nothing forever. And that was the basis on which CASCAIDr was set up, to provide a means for giving legal advice away for free, but also charging for some of it, so that what we charged for could offset the cost of what we did for free. And that worked for a while, but it ain't working since COVID. And it isn't working any longer in an environment in which information and training has become something that people do for free in order to do marketing. Much of what is free by way of information on the internet is not worth having. But I don't want to work in an environment where I've got to dumb down what I say in order to make it bearable to prepare properly. So these public law principles podcasts have been effectively my old school way of trying to ensure that even when we close to new referrals for 2 months until the end of February, when a decision will be taken, public law principles are out there, and there is no excuse for public bodies not to use them, because they are on YouTube and they are there for free.
So that social services have been privatized now that the legal aid is not supporting the barristers and the solicitor to support people to achieve a level of care for the person they care for.
The advice sector as a whole is struggling. But Access to Justice, which is a charitable foundation, is shortly going to announce, I think, about £25 million worth of spending in the advice sector. We just know that we aren't going to get any. So we don't know who is. So I may be being unnecessarily negative, but for the future, you should be looking out for information about where access to justice, community justice funds money, where it is distributed to. My guess is it's going to be to law centres where there isn't much community care law being done at the moment. And then that may well see a turnaround. There may well therefore be somewhere to send people when they have these problems. We are still continuing our Q&A service. So during our closure to referrals, if you can distill your question down to a one-liner, practically, we can still answer that kind of a question because I'll be doing that just to keep my hand in. All right. So happy Christmas to everybody. Thank you very, very much for listening and staying the course, being the hardcore. Thank you for the clap. That's very much welcome.
Asks for donation. Is there a standing order where they can donate every month, certain level of
we would love that, and our website donation link will remain open. So as we work for a reconfiguration, the senior management team will be putting out material that reminds people that we're still here and we're still trying.
So there's a standing order form there on the website.
There is a means to make a regular donation. Yes.
Okay. Right.
All right. Thank you very much, Mary, and thank you for your interest. I've enjoyed your questions each week, and good luck to everybody else. I see in the chat there are some goodbyes and thank yous, and I very much appreciate that. But I'm going to go and have a rest now. All right. Thank you. Cheers. Bye-bye.